Hi, welcome back to Frequently Asked Fridays, where we here at Martin IP Law Group answer your questions about intellectual property and related matters. Today we're going to talk about a question which we get quite often, and that is, what is the difference between a provisional patent application and a non-provisional patent application? And it's fairly simple. The provisional application itself is just merely a placeholder. It's a way to get an application on file quicker and cheaper than filing a non-provisional application, which has to have a lot more information in it, for less money. So the provisional application really gives you it's a placeholder and it's good for 1 year. So it gives you that year to test out the market to see if your invention has commercial applicability and whether or not there's something there that justifies spending more money and going on to the next step and continuing to pursue a patent on that. So the provisional application, again, is just a placeholder. It's never going to be examined for patentability. What a provisional application does have to have is it does have to have a full and complete disclosure and description of what your invention is. What it does not have to have are claims. Claims are the numbered paragraphs at the end of a patent that ultimately define the legal scope of protection that your invention is going to get. Since the provisional application isn't going to ever be examined for patentability, no need to have the claims in there. We here at Martin IP Law Group feel that the claims really are one of the most important, if not the most important part of the patent, since that defines the scope of protection that you're going to get. We really want to make those claims as broad as possible so that someone can't make some minor modification and do an end run around your patent. So the provisional doesn't have to have those. So the way we prepare a provisional application is we do the full disclosure. We do the drawings. We do the description. We do the background. We do everything that's needed to put the meat on the bone, so to speak, but we don't write the claim. Then when you want to turn that into the non-provisional application sometime within the next year, all we have to do is come back and finish the job and write the claim. So it's a cost deferring mechanism in that respect, in that you're not paying all of the fees up front to prepare a full-blown non-provisional application. You're essentially paying half of that fee now to prepare the provisional application and deferring half of that cost until up to a year later when we prepare and file the non-provisional. The downside of filing a provisional and going that route is that it's going to take ultimately up to a year longer for a patent to issue on that application. But again, the good side is you get that extra year, you defer your costs, and it allows you to kind of spread things out a little bit and not have all of those costs up front at the very beginning. So I hope this has been helpful. I hope that explains the difference between the two. If you have an invention that you want to patent, come talk to us. We'll walk you through the process and discuss which option is best for you. Thanks. Have a great weekend.